Here's the case. It's Gina Carano versus Walt Disney, Lucasfilms, and Huckleberry Industries. So her against everybody that fired her, that she had a contract with, a relationship with. And this is a case in the federal court for the Central District of California. And this is an order denying defendants' motion to dismiss. So Disney moved to dismiss based on the basis procedurally. It's a motion to dismiss procedurally, but on the argument, the substantive argument of freedom of speech. So Disney, like always, tried to come out and say, my free speech, my free speech. Remember that with the Florida case? Remember how in Florida that didn't work out so well for them. These are the same fucking lawyers that keep telling Disney to just argue my free speech every single time and it's going to work. It hasn't. You should stop that tactic. It's a bad tactic. It's not working for you. Right? And I called that. And on the point, this argument is a bad argument. There's other arguments. Make procedural arguments, make maybe anti-slap arguments, whatever else. But this one is not great. And once again, my government. Oh, they're trying to come for me. It's not a great argument. That applies in many contexts. You know, whether it's a cocaine charge or defending against a motion to dismiss. Now, Disney and its co-defendants motion to dismiss. They filed a motion to dismiss for failure to state a claim. Okay, so procedurally, this is the first motion here. Now, the court denies this motion. We're going to go into why, but let me tell you why this is so important. Okay, right off rip. We now will go into discovery. So now we get discovery. Now we get the emails. Now we get the text. Now Disney's going to fight it. They're going to fight it tooth and nail. They're going to cry. They're going to say it's confidential. They're going to say work product. They're going to say all these sorts of things. They're going to fight it. But oh boy, they're going to eventually take it. Because once again, when you've got parties that have money, when it's Elon's lawyers, it's not some random Joe. It's not some like one lawyer shop. No, these are like Elon's team of lawyers here. It is not going to be good. Real lawyers, practicing lawyers. So what's the factual background? Gina Carano was terminated from Mandalorian after posts she made on social media. And mind you, this is the judge's summation. This is why reading this is so important, because this is how the judge sees the facts. So this is not how Disney sees the facts or how even Gina sees the facts. It's how the judge sees the facts. So Gina was terminated based on posts she made on X, formerly known as Twitter, and Instagram. Defendant chose plaintiff, excuse me, to play the character of Cara Dune in the Star Wars series, and her employment became effective on September 18, 2018. On February 10, 2021, however, defendants abruptly terminated her employment after she reposted content created by another social media user. After hiring plaintiff, defendants prominently featured her in promotional materials for the show. Her contract for the first season designated her as a guest, entitled to a minimum salary of $25,000 per episode in which she appeared. Given the popularity of it, plaintiff's agent sought an increase for the second season, but defendant refused, offering her a one-time bonus of $5,000 in the same 25. That's cheap as fuck. $5,000? Like, that's it? Like, oh, you did a really good job. Here's $5,000. Like, I mean, for how big the show is and how much they're paying for other shit. It's actually not enough. That's actually kind of nothing. During the summer of 2020, plaintiff began receiving frequent messages on social media to support various causes, adopt various ideologies, and hold herself in a certain way. In particular, social media users urged plaintiff to publicly support Black Lives Matter. So she was supposed to support BLM, including endorsing certain slogans associated with the movement and to indicate her preferred pronouns in her social media account. Guys, compelled speech. They were trying to compel her to use pronouns, right? When she did not use pronouns, Members of the public accused her of being racist and leveled epithets at her, including one who called her a transphobic bitch. Although one of her castmates supported her on social media, defendants did not intervene. So the company did not do shit. They didn't defend her at all. Plaintiff criticized certain COVID-19 policies requiring businesses and churches to remain closed while allowing public protests. This was clearly illegal, by the way. This is clearly illegal, what they did during COVID. And the fact that we allowed that, the fact that anybody justified that is sick. It's disgusting. And I called this out when it happened. This is actually when I started my channel. I called this out. This is sick and fucking disgusting. Plaintiff alleges she was attacked for these views, and defendant made known their disapproval of plaintiff's position. 1 week later, September 12th, frustrated by social media users' continual comments and critiques regarding her choice not to include her personal pronouns in her Twitter bio, plaintiff put boop, bop, beep in her profile, right? Referencing sounds a droid would make, okay? So she made droid noises, but that triggered a lot of people. I'll tell you that. That's not in here, but I'm telling you, it triggered people. She deleted this material after a short time after originally posting it and shared that she had spoken with her castmate, Pedro Pascal, but why other individuals listed their pronouns in their bios, right? So good old Pedro, it's like, oh, that's why they do it, right? At some point, defendants began demanding an explanation from plaintiff and criticized her for not embracing social media users' demands that she list her pronouns. Defendant engaged plaintiff in long phone calls, constant meetings, and what plaintiff refers to as a re-education program. They put her in a re-education camp. She had to meet with representatives from the Gay and Lesbian Alliance Against Discrimination. So this implies that she's a bigot. Her own company implied she was a bigot. However, she did so. And she reviewed several documentaries that asked her to watch. And the representatives provided positive feedback to defendants. So they said, okay, she seems to be very thoughtful about this, right? That's fine. Not satisfied, however, defendants continued to demand that plaintiff issued a public apology, including by asking plaintiff's publicist to force plaintiff to issue a statement admitting to mocking or insulting an entire group of people. So they wanted to compel her to admit that she did something wrong. They wanted her to kneel. Then she was demanding a public apology. Would that have fixed it? No. And she refused. She finally drew the line and refused to issue it. And she gave an alternative proposal, I think, of, just a different statement, a different type of statement, right? Don't bend the knee, guys. Don't give them a fucking inch. Tell them to fuck off. You're always better with that. They will take advantage of you. Interesting in showing her good faith, plaintiff sought to donate to a GoFundMe page purportedly created to support the transgender community. So she was going to donate. She was going to donate in good faith to the trans community. Upon visiting the website, however, she read that the page list that had been created by a Lucasfilm employee and described her as a bigoted actress. So she was going to donate to them until she read it and found out the page was created by a Disney employee who called her a bigot. When plaintiff brought the website to Lucasfilm's attention, Lucasfilm denied any of its employees had created it. They had, though. Shortly after, the page was altered to describe plaintiff as ignorant. And its organizer was changed to no longer identify as a Lucasfilm employee. To plaintiff's knowledge, no Lucasfilm employee was ever disciplined. They were not. I guarantee you they were not. And we're going to get, by the way, this is the emails we're going to get. See, now we're going to get the emails where they were probably congratulating her. Imagine this, guys. Imagine we get emails where they congratulate the employee for attacking her, or they support it, or they condone it. That is even worse, right? That is a huge windfall for Gina Carano. She wins big on that one. You might get punitive damages on that one, right? They're fucked if they have emails on this, and I guarantee they do. By the way, text messages, Disney is screwed. Defendants informed plaintiff's publicists that they would require plaintiffs to participate in a video conference with Lucasfilm president Kathleen Kennedy and 45 defendants' employees who identified as part of the LGBT community. Once again, a struggle session. So they wanted to struggle session her, right? So Kathleen Kennedy and this were going to litmus test her. Although several of these employees had contributed the above-mentioned GoFundMe account, defendant encouraged plaintiff's publicists to describe them as a friendly group. Okay? Plaintiff alleges that in defendant's view, she had to grow and learn. So they were not willing to accept her as she was. As she was flawed. She needed to grow. Until defendants knew where her mindset was regarding pronouns. So they needed to change her mindset. Defendants would not allow her to speak to media and would not include her in promotional periods. So they were punishing her. She declined the proposed meeting, but agreed to take a smaller group meeting of 5 to 6 employees to dinner for a face-to-face discussion. A counter offer, which she didn't agree. And the reason for that is because this 45-1 is not a discussion. It's you being fucking lectured, right? This is you being pilloried. This 5 or 6, you can have a real discussion, right? But this 46, because Kathleen Kennedy's on the 46-1, this is fucked. And your mind changes the way you perceive those things. A small group is like more like familial, right? But this large group, that's a gang up, right? That's a lynch mob. That's a modern day lynch mob. Just over a political opinion. Plaintiff suggested she might need legal assistance. Defendant insisted media undergo. So when she asked for a lawyer, they said, oh, no, you need media training. You don't need a lawyer. You need media training. Look at this. So she faced backlash of her statements regarding the 2020 election process. As an example, when she said we need to clean up the elective process and calling for laws to protect us against voter fraud and voter ID, they complained, saying her political views do not match what is expected from their stars. They expect her to toe the line of the Democratic Party. They said that. They said this. This is a quote, guys, of Disney. Their political views do not match what they expect. They're saying here that they expect them to have these views or they're going to be fired. This is damning for a company. All the while, the plaintiff continued to promote Mandalorian, and by early 2020, she was responsible for half the talent engagement on social media. Literally, guys, half of the engagement related to the show, half of the engagement related to the show was not Pedro Pascal, it was Gina Carano. That's fucking nuts. That's nuts. On December 21st, 2020, after plaintiff made her first appearance in the second season, Lucasfilm employee Lynn Hale emailed plaintiff to congratulate her on the episode's success. Around that time in 2020, The Mandalorian's creator, Jon Favreau, told plaintiff her life was about to change. Disney approved a spin-off to be entitled Rangers of the New Republic, where she would be the lead character. As a lead character, plaintiff would have been a series regular. Series regulars receive long-term contract with base compensation beginning $150,000 to $250,000 per episode. A substantial, a wild, that's a 10x over her current pay. Favreau also represented that plaintiff would be part of a series of Star Wars movies based off Disney Plus, including The Mandalorian. In 2020, Kennedy confirmed the production of Rangers of the New Republic spinoff at the Disney Investor Day. Hale inadvertently sent plaintiff an internal communication containing Disney's discussion along with a hashtag Fire Gina Carano. So they were already they started talking about that on January 2021 internally. The email first pertained to backlash that CEO Bob Chapek made after the Jan 6, 2020 insurrection. Much of this criticism concerned concerned Disney's business with China. But certain members of the public also called on Disney to fire Plaintiff. Yeah, because Disney had a lot of business with China, a lot. In the email thread, Disney quickly focused on Plaintiff rather than its business dealings in China and began preparing a report on Plaintiff. See, they want to distract from that because Disney chronically underreports its business dealings with China and how fucking shady they are and how much they have to bend the knee to kiss the ring in China. Plaintiff alleges that Chapek intended to use Carano to deflect attention from his failed leadership as Disney CEO. On January 12th, Plaintiff posted an interview in which she discussed the controversy concerning her social media activity. And she says that around that time, the official Star Wars Twitter account issued a statement of support for another employee who faced criticism for certain statements she made regarding racism. So publicly, the Star Wars Twitter is supporting other people, but it's not supporting Gina. Plaintiff shared on social media that questioned the difference between those who hated someone for their political views and citizens in Nazi Germany who hated their neighbors simply for being Jews. As relevant to this action, castmate Carl Weathers had previously shared similar messages on social media. Although Plaintiff alleges his posts were interpreted to attack Republicans and were accordingly acceptable. So because Carl Weathers was attacking Republicans, it was acceptable to Disney. Disney's okay if you attack Republicans. You can post stuff calling people Nazis. Same thing. Pedro Pascal also posted the same sort of things on there comparing Donald Trump to a Nazi, and they did not fire him for that. So saying his supporters are Nazis. Because that was okay under their political view. Pascal also posted Disney-owned Muppet character with a pride flag and messages to Black Trans Lives Matters and defund the police. So Pedro Pascal is posting very wild stuff, including stuff with supporting, some questionable organizations. Disney did not comment on any of these, nor did they discipline Pascal, require him to review documentaries or attend meetings with contrary points of view, pressure him to apologize, or refer to him on social media as abhorrent. Similarly, Star Wars actor Mark Hamill, good old Mark, who's running his fucking mouth. Mark Hamill, who can't shut up with the bad takes on X, has been running his mouth, calling Republicans and Trump Nazis without objection, because that's okay. You can do that. In fact, Mark Hamill made a guest appearance during the final episode of the second season. Luke came back. Right? The problem is that people are saying it's a political company. You can't be a political company when it comes to hiring and firing. At least not in California. In response to plaintiff's post, however, defendants terminated plaintiff that day. Defendants released a statement characterizing her post as abhorrent and unacceptable because it denigrated people based on their culture and religious identities. Chapek further explained the defendant fired plaintiff because she didn't align with their values. So saying they don't value free speech. They canceled Rangers of the New Republic. They also, after termination, she was stalked, causing her to fear for her personal safety. Oh, also, as a final point of contention, plaintiff additionally highlights defendant's decision to rehire James Gunn 1 year after terminating him for social media posts about rape and child molestation. Plaintiff also alleges that defendants engaged in a smear campaign against her following her termination. For example, in November 2020, plaintiffs filmed an episode of Running Wild with Bear Grylls, Running Wild, a show that aired on Disney Nat Geo. So Disney, Gina Carano was in Running Wild with Bear Grylls. After terminating plaintiff's employment, Disney removed this episode from Running Wild's lineup. So Disney went out of its way not just to fire her, but to purge her from their media library after protests from fans and intervention by Bear Grylls. So Bear Grylls had to intervene and be like, yo, bro, what are you doing? What are you doing? Right? They reversed the decision, but removed her name and likeness from promotional materials as well as the episode listing. Following her termination and defendant's statement, plaintiff's agent and an entertainment attorney both dropped her as a client without explanation. Wow. You know why? Disney probably put pressure on them. I want to get this fucking attorney's deposition. Let's depose this fucking agent and an entertainment attorney, because these fucking worm attorneys, and we see this, by the way, you guys see this, there's attorneys that have no ethics, right? This fucking slimeball lawyer, this fucking Saul Goodman over here needs to be, actually Saul Goodman's is actually better than this person would be, right? Needs to be put out there. As an attorney, you have a duty. As an agent, you should have a duty as well to your client. But you know what? This agent was afraid of being blackballed by Disney. All right. So it's just literally a claim has to be plausible. All we need is plausibility. And we assume the facts are in the light favorable to the plaintiff. So we construe everything in the light most favorable to the non-moving party, meaning the plaintiff. So in this case, they are not required to accept all true allegations that contradict exhibits, nor must they accept allegations that are conclusory, but they must interpret all facts in the light favorable to the plaintiff. Okay? So a defendant may not ordinarily raise affirmative defenses as a basis to dismiss a complaint. However, there's an exemption when the defense raises no disputed issues of fact. So Disney was saying there's no disputed issues of facts here. So California law. Okay, so some lawyers kept talking about this in like federal law terms, but the problem is there's California law, and the California law is more specific than federal law. So what California law says is that employees are protected for their political activity. So employers may not adopt, enforce any rule, regulation, or policy forbidding them from engaging in politics or trying to control, direct, or tend to control or direct the political activities or affiliations of her employees. So on its face, they're trying to control her beliefs. They're trying to control her politics. California law provides no employer shall coerce or influence or attempt to coerce or influence through means by threat or discharge or loss of employment of any particular line of political action, political activity. And in California, they thought this was just going to be used against evil Republican corporations because all Republicans are evil, right? So, and they're all the ones that own corporations, right? That's what they believe in California. But little do they know that in the modern day and age, actually it's flipped the other way. I wouldn't be surprised if this California law gets repealed at some point. By the way, I wouldn't be surprised if this California law gets repealed because California doesn't want it used against woke corporations. I actually think they're going to repeal this at some point because they're going to be worried about they're going to be like, oh, wait, we control the corporations now. This was passed when we thought we didn't, but we do now. They may try to repeal this. I'm being honest with you guys. Once again, I try to be honest with you guys. Probably after Gina, they will repeal. If Gina wins, I think they'll repeal. I mean, California wants to get rid of civil rights. You guys know that? Because the fact that we have civil rights keeps us from being discriminated against if you're a man or you're straight or you're white. But they want to get rid of these laws because they want equity. They want the laws that allow them to discriminate, like Canada, where they recently changed the Canadian Charter to be able to actively discriminate in the name of affirmative action. As long as I call it that, they can do it. Anyways, separately, the labor code says you cannot discharge any employee. Well, that's what they did. They discharged an employee. They fired somebody because they were engaged in political activity and the conduct that was described in the chapter, political activity. And if they do that, they get reinstatement and reimbursement for lost wages and work benefits. So all of that money that they would have gotten, they get that $250,000 per episode. Oh, buddy, she gets it. Also, their Fair Housing Act says you cannot discriminate on basis of sex. And because the men were treated different than the women, You have a sex claim here. So here, defendants assume without conceding the complaint adequately claims for wrongful discharge motivated by a political activity for unlawful sex discrimination. However, they assert they're barred by the First Amendment. So their argument is that they actually assume that she does state a claim. So the thing is, Disney's whole approach is that they didn't even fight the fact that she didn't have a claim. They went with, but the First Amendment, but my First Amendment. But my First Amendment. They don't, this is what I said here, they don't contest the facial constitutionality of the California Labor Code. They should have. If they wanted to do a good defense, if these attorneys knew what the fuck they were doing, they would have at least tried to do that. Because challenging the constitutionality would have been a better argument than the argument they brought to court. Going, my First Amendment is weaker than trying to get rid of the law. But the reason they don't want to get rid of the law is because Disney is homies with Gavin Newsom. And if they were to get rid of a California law, that would be egg on little Gavin's face. So in these circumstances, defendants argue imposition of liability for wrongful discharge and sex discrimination would unconscionably burden their right to their own free speech from association with their high-profile controversial speech. So, okay, let's talk about what free speech is. Free speech applies to the states under the Due Process Clause. So yes, it applies to the states. The guarantee of free speech guards only against encroachment by the government and erects no shield against merely private conduct. The First Amendment protects not only political and ideological speech, but speech occurring in entertainment as well. Furthermore, various forms of media that are published and sold for profit does not prevent them from being expression. Because the First Amendment guarantees implicit in the right to engage in activities protected by the First Amendment is a corresponding right with others in the pursuit of political, social, economic, educational, religious, and cultural ends. Government actions that burden that take many forms. This is regulation or public accommodation. Keeping out gay rights activists is what the example they use here. However, the right to associate for expressive purposes is not absolute. Where a facially viewpoint neutral law is tailored to serve compelling state interest, the state may be able to justify any derivative impact that has on a party's associational freedoms. So there's a case where they rejected an organization's claim in Minnesota anti-discrimination law requiring an organization to accept women as all full voting members imposes a serious burden on males members' freedom of expression. So it's a law that says, hey, there's limits, right? So you as a group, because what they try to argue is this, is that as an organization, we have our right of association. We have the right to associate with the people we want to associate. And that is partially true because in America, we've actually revoked certain types of rights. So I know this may sound bad, and it is bad, but for example, we've lost the ability to segregate groups by gender. So if there wants to be a women's only group or men's only group, it's very hard to do that. It's very difficult to do that because of the way our laws have evolved, right? For better or for worse. For better or for worse, right? So defendants urge the court to read Dale together with Hurley, which is Disney. So Disney wants them to read this case about private organizers of a St. Patrick's Day parade to allow a group of marchers who wish to express their pride in their Irish heritage as openly gay, lesbian, and bisexual to march in the parade creating their own banner violated the First Amendment because it required the private organizers to alter the expressive content of their parade. So they literally said, okay, because Disney's like, we are like the Irish St. Patrick's Day group that was allowed to prohibit a pride presentation during their St. Patrick's Day parade, right? Because it changed the nature of that. And that was allowed. They were allowed to exclude those people. And they're saying that's like us. Well, no, that's actually not like you, right? Once again, this is great. Neither Dale nor Hurley arise in employment context, so they're not in a St. Patrick's Day parade. That's not an employment context. You're not forced to be there. There's no employment rights, right? When you're employed, your kind of rights and responsibilities change. We've allowed things to be regulated when you're employed that are not regulated when it's just a bunch of people coming together to do stuff freely. It's different. It was grasping at straws. Very good point. When defendants' expressive association rights bar plaintiff's suit, do they bar it? Right? So an organization that claims protection on the First Amendment must determine whether the group engages in expressive association. Although the First Amendment's protection of expressive association is not reserved for advocacy groups, a group seeking such protection must, by its associational choices, engage in some form of expression, whether public or private, that it infringes upon. So what is the expression that they're infringing upon? So in Dale, the Boy Scouts engaged in expressive activity because it sought to instill certain values in its youth members by having adult leaders spend time with and instruct those members. Two values that the Boy Scouts claimed to champion were values represented by the terms morally straight and clean, right? The Boy Scouts represented that it teaches that homosexual conduct is not morally straight, in the official position that avowed homosexuals were not to be scout leaders. The Supreme Court concluded that enforcing New Jersey anti-discrimination law requiring the Boy Scouts allow Dale, who is openly gay, to serve as an assistant scoutmaster would have forced the organization to send a message contrary to the values. So the Boy Scouts were allowed to disassociate. By the way, are you guys noticing something really funny here? That Disney, for all their pro-LGBT stuff, the two cases that Disney chose to cite are anti-LGBT. Do you notice that? The two cases that Disney chose to cite are anti-LGBT. Isn't that crazy? So in this case, where Disney is trying to be the defender, my defender of pronouns, Disney is literally trying to defend pronouns, and they're taking the side legally of people that are anti-LGBT. Isn't that interesting? Is it interesting how they do that? Right? Now, of course, it's a legal argument, and I don't blame the lawyers for making that legal argument. It's the best legal argument they would have using their insane First Amendment theory, but it's very interesting, right? And they're using it because it's case law. Yeah, they're using it because it's good case law, but it's inapplicable to their case. I just think it's hilarious. It's an irony. It's just an irony. That's all. So let's just scroll down here. Here, although defendants indisputably engage in expressive activity, including promoting and disseminating The Mandalorian, they have failed to establish they engage in expressive association. So people are not, Gina Carano is not affiliating with them out of expressive association. She's their employee. She's not joining Disney because she's politically aligned with Disney or morally aligned with Disney. She's joining Disney because she's their worker. That's a different context. Further, at this stage in litigation, the court cannot conclude, as defendants urge, that plaintiffs' continued employment would inhibit or intrude upon their right to expressive association. As an initial matter, unlike the Boy Scouts or the JCs, defendants are not a members-only nonprofit organization. They're not. They're for-profit. They're one of the bloodiest, most ruthless profit corporations out there. Instead, they're a for-profit corporation who employ actors, such as plaintiff, as well as administrative staff. This is relevant. Super relevant. I didn't even think about this one initially, but this is a great point. Speakers do not shed their First Amendment protections by employing corporate form, but to substantiate a claim that they employ public-facing actors for the purpose of promoting the values of respect, decency, integrity, and inclusion is not something there's any evidence for. Accordingly, defendants' invocation of this supposedly detrimental effects of their mere presence as one of defendants' employees lacks constitutional import. So there's no importance. Their argument is bunk. right? And this is a theoretical one here. Finally, it's unclear at this stage of litigation whether defendants could establish that the enforcement of California's anti-discrimination law imposes burdens beyond those necessary to accomplish the state's legitimate purposes. So meaning there's no real burden on them. They're not forced to disassociate with anybody because of Gina Carano. So there's no sort of public interest in protecting the right of them to fire Gina Carano. That's not something that's utterly important for the public. Therefore, the court denies the motion that their expressive association bars plaintiff claims. Now, next, where their right to control their speech bars plaintiff's suit. So they're saying that they have speaker's autonomy, right? So defendants argue that their claims are barred because the entities engaged in the expressive communication may choose to exclude their own communications with other speakers. And defendant believe would impair their ability to convey their own preferred message. So saying that by Gina Carano tweeting, that's going to impair their own message. So people are going to think that Gina Carano's message is their message. I don't think anybody is confusing that. I don't think anybody is thinking that Gina Carano's tweets are official tweets from Disney. I think it's preposterous. Specifically, defendants contend that if allowed to proceed, plaintiffs' lawsuit would unconstitutionally interfere with their control over the Mandalorian. What the fuck? They're saying they're going to lose. They're going to lose control over the Mandalorian because of Gina Carano's tweets. How impotent are you as a company that you think you're going to lose control because someone's tweeting mean things? You're fragile little bitches. If that's where you think you're at, you're going to lose control over your team. That's their argument. Disney argued that. Disney, to a judge with a straight face, said, if we allow this, we are losing control over the Mandalorian. She is controlling it. We're not. It doesn't make any sense. Court agrees that plaintiff that defendants' conclusory assertions of impairment do not suffice to establish a First Amendment bar to plaintiff's claims, especially in light of the Ninth Circuit case law that dismissal is appropriate only when the plaintiff pleads itself out of court by admitting all the ingredients of an impenetrable defense. This is not an impenetrable defense. Guys, this is a defense with more holes than Swiss cheese. This is a defense that's been penetrated so many times that you would think it dropped the soap. As well established, right? Televised programs qualify for First Amendment protection, and nobody disputes that. However, defendants, Disney enjoys the right of control over casting decisions. Disney can decide who to cast. Gina Carano, because she tweets, is not suddenly controlling the casting decisions. Gina Carano, because of her tweets, is not suddenly taking away who gets hired and who gets fired. Defendants contend that the messenger here, plaintiff, is part of the message. However, courts outside this circuit have recognized a circumscribed, that means limited, people. That means limited, right? To make casting decisions free from anti-discrimination. So you can pick people based on race for a show. It's okay because you might be able to have to fill a role, right? That's recognized. Casting and the resulting work of entertainment as inseparable. So because the casting is not changed, the casting is not altered, that power, right? Reasoning that any First Amendment protections for the end product must apply to the casting process, right? So the First Amendment covers the casting process. Interpreting the plaintiff's complaint, and I'm skipping some of the case law here. The court concluded that Hadestown was making its casting decisions with an eye towards how racial composition of the musical's cast affect the story that Hadestown was telling on stage. And Hadestown was meant to be a story about it was involving a black woman hired as a member of a chorus in the Broadway production, right? Because they were sensitive about conveying a white savior story, so they decided to change the racial composition of the chorus, right? So when their casting decisions were challenged, the court dismissed it, right? The court dismissed that. So extending defendants' First Amendment rights to plaintiffs' retaliation claims would impermissibly enable defendant Disney to terminate any employee who is engaged in a protected activity, such as complaining about working conditions, under the auspice of creative decisions. This is what Disney wants. This is it here, right here. This is it, guys. This is it. If Disney was to win this case, it would allow them to terminate any employee for any protected reason, including race, gender, whatever, because they say it's creative, right? That's what Disney wants. They want the power to do whatever the fuck they want because it's creative. No, Disney's been breaking the law. They've been in a separate suit. They've been openly discriminating against people they hire. It is time where the piper comes in and says, you are not getting to get away with it because you're magic, because you're special, because you're big, because of Walt, the person whose grave you desecrate every single day with your abhorrent, disgusting behavior. This is the point where the court is calling them out and is saying, enough of your bullshit. Enough of your bullshit. Creative decisions. It's a lie. Within this circuit, one court has rejected a broad First Amendment claim to immunity over casting decisions in a similar case. In that case, creators of a soap opera, The Young and the Restless. Ooh, The Young and the Restless. Oh, we all remember The Young and the Restless. Argued the plaintiff's suit over the refusal to rehire her after she advocated for more racially diverse casting was barred by the First Amendment. In that case, the actress who performed the show for nearly 2 decades alleges defendants decided not to rehire her in retaliation for protected speech, not due to discrimination in the casting process. The court thus concluded the plaintiff's claims were unrelated to the creative vision and did not raise any First Amendment concerns. Plaintiff's complaint does not take issue with the message or content of The Mandalorian. Yes, this is it. She does not allege that Gina was fired because defendants wished to have fewer female roles or because they made an artistic choice to modify the cast to include liberal-only leaning actors. Instead, plaintiff contends defendants fired her in retaliation. That's the problem. It's in retaliation for off-the-job political speech. Therefore, their motion misconstrues the proper framework for evaluating facial allegations within complaints. Right? Indeed, the procedural posture of this case, as well as the distinguishable facts and issues, stand in stark contrast to the other cases defendants cite. Bro, blowing their cases out of the water. The judge is saying your cases ain't shit. And by the way, they say here too, defendants might, with a more developed factual record, be able to prevail in their First Amendment claim. But what this means is you have to go to trial. If you want to try to prove this, if Disney wants to win, they only have a chance at trial, but not before discovery. And the damage in this case is discovery, is the emails. It's not trial. It's the dirty laundry we're going to get to air here. We're going to expose their propaganda, and we're going to expose that Disney has been nothing but a propaganda machine under Bob Iger. Redgrave concerned Boston Symphony Orchestra's decision to cancel a series of planned performances with Vanessa Redgrave after receiving calls from subscribers and community members protesting her support for the PLO, for the Palestinian Liberation Organization. At the conclusion of the jury trial, they awarded Ms. Redgrave $100,000, but on the BSO's motion for judgment notwithstanding a verdict, the district court held that Redgrave could not recover consequential damages due to First Amendment limitations. On appeal, the First Circuit discussed at length the grave concerns about the conflict of rights created by Ms. Redgrave's civil rights claim. However, they resolved the issue on state law grounds, concluding Massachusetts law did not give rise to a cause of action for refusing to perform an artistic work. However, given the differences between Redgrave and this lawsuit, including governing law, Redgrave is of little persuasive value. Once again, Disney lawyers cited a case that was completely fucking irrelevant. This is what they did in Florida, too. They did the same thing. Disney lawyers will cite cases that are way off point. Way off point. So they go through more off-point cases like Hurley. And like here, in contrast, plaintiff's complaint alleges that defendants terminated her from The Mandalorian not to control the show's content, but as a form of retaliation. So once again, they're keying in on this is retaliation. This is not a form of setting the message of the show. It doesn't change the story of the Mandalorian, right? So let's go here. Finally, after the parties' hearings, defendants filed a notice of supplementary authority asserting their position is supported by the recent case Moody versus NetChoice. It's a very recent case in 2024, July of 2024. So super recent. So this is probably why the court took so long to do this, because they were trying to go over this Moody case. So some people were wondering, because we had an inkling that the judge was going to rule, but there was a new case. So this judge was probably carefully considering the new case law and saying, does this apply here? Does this case law apply here? So that's actually a good judge. This judge did a good job. I actually enjoy this. Plaintiff's lawsuit concerns a scripted television show, not a forum or a curated compilation of speech originally created by others. The court does not dispute defendants' general right to control their expression. Therefore, once again, Moody does not address it. So Disney literally raised an irrelevant case, a completely fucking irrelevant case. You know why? To stall for time. This is what Disney's lawyers are very good at, guys. I've told you this. Pay attention to this. In all the cases with Disney, Disney's lawyers, their number one strategy is to stall for time because they want to bleed you of money and they want to get this out of the media cycle. So they try to stall for time, stall for time, stall for time. It's their number one tactic. I don't let them get away with it because I call them out. I call them out on it in my channel. I said, we're going to be right. Let's just wait and be patient. We're going to get that W and I'm going to dunk on them when I get the W.